Excusable delays. What is an excusable delay, you ask? And what a coincidence that we have an answer right up on the screen. It's amazing how these things just work out that way. Excusable delays are those that arise from unforeseeable causes beyond the control and without the fault or negligence of the contractor, including but not restricted to acts of God, acts of the public enemy, etc. And there's a whole list of things, and they are all in 2107-0113. That gives you an example of what are reasons that are beyond the control and without the fault or negligence of the contractor, and thus will allow an excusable delay. For an excusable delay, the agency will not invoke any type of remedial action that otherwise would be appropriate. It's excusable. We're saying that we're okay, not that we like the fact you're not doing it, but it falls into one of the acceptable exceptions to you not performing something within the time frame specified. And because it falls within one of those acceptable circumstances, we're going to excuse the fact that you are not meeting something. So we're not going to come back to a remediation plan. We're not going to try to collect on liquidated damages. We're not going to try and collect on a performance bond. We're not going to do anything that we would do if you did not have an acceptable circumstance that explained why something wasn't being performed. The general excusable delay clause in 2107-0113 is sufficient for most purposes. This clause is broad enough that most circumstances that would be construed as being excusable delay can be accommodated under this provision. However, there can be circumstances that may be gray areas as far as whether they are excusable under the general provision. So, and this is something you would do in the planning stage, you can add specific provisions that will be considered to be excusable, so that there is no question whether the general clause applies. So, number one, you could simply use the standard clause, the wording in 2107-0113, and simply, if you have any situation where the vendor alleges that its non-performance is excusable because one of the circumstances, and it goes with strikes and freight embargoes and natural disasters, force majeure, there's something opposite force majeure. As it said, force, well, it's something like that. It's the Latin for minor. Strikes, freight embargoes, like natural disasters, the public enemy is already up there on the previous slide. But in so many words, it goes to the things that are excusable, and the question is that sufficient for in any circumstance for the procurement officer to make a determination as to whether non-performance is excusable? And if you aren't comfortable with just trying to make an interpretation under those general activities that are in 2107-0113, what we're saying here, and this is something for planning, typically, would be that if you can foresee other circumstances when you know that they might occur, that you would be willing to identify that as an excusable delay, you can write that specifically so that it gives more clarity to what will be accepted as an excusable delay. So excusable delay. And at this point, Mark will jump up and tell you when he has done an excusable delay. When you thought a contractor was having difficulty and you wanted to not invoke penalties or something. All right. He's not picking up on the cue. All right. We're going to go to internal review. We're doing internal review. We're reviewing internally. An agency may reconvene the project team on a scheduled basis to review. So we've said before that, well, I don't know if we have said this before, but at some point when you first are planning for a procurement, at some point when you're going through the procurement, at some point after you've awarded a contract and you're into the execution phase, we have advocated that for major contracts there should be a team of appropriate people that help guide decisions first of all, what the requirements are, what the selection is, what are their performance on the contract, things of this nature. So one of the things we're hearing now is that you may have a scheduled thing. You may say every 6 months, we're going to reconvene this team just to do a formal review of what has happened thus far under the contract, to see, number one, and not just whether the vendor is doing what they're supposed to do, but some of the other part, and why we're calling this project management. Are we doing what we're supposed to do? Do we have the adequate state resources? Have we had attrition of the people on the state side that have to provide some activity for the vendor, which is causing difficulty for the vendor? Are we providing information? Is there something about our IT system that is now causing problems that were not identified previously? But is there some problem on the state side? Yes?
Well, does this project team, does it involve a vendor as well?
No. This is a state, the vendor, you're having meetings with the vendor routinely. And the vendor might be bringing up these things, but the vendor, maybe they say they're being held up by lack of decision or certain things by the state. This is something where it's the internal state people who may look at funding levels. Are we having a reduction in funding? Are we getting more funding? If we have more money, what would we do? If we have less money, what would we do? Talk about, do we need to go to higher up to get, let's say, a freeze exemption to fill a position? Do we need to go and try and get more money because we know that unless we do, we're going to have to modify the contract to reduce the scope? Should we have to find space, whatever the situation may be? That's one of the considerations of, are we doing things on the state side? And removing impediments on the state side, if there are any. The contractor's performance, the progress made on completing the contract, including MBE compliance, the adequacy of the contract in meeting the needs of the project. Sometimes you reevaluate, do we still want this the way we have originally contracted for it? If this is 2 years down the road, if we say they meet every 6 months, let's say, and now you're into the 4th meeting at the end of the 2nd year, have circumstances changed to such a degree that even though the vendor is doing what the contract called for, now might we want something different? Do we want to take it in a different direction? Do we want to cancel it? Do we want to reduce it? Is there something that we want to change?
Question.
Yes.
Who is responsible for the MDE compliance?
Yes.
Because I'm
The
getting
person
involved.
responsible for the MBE compliance is whomever the agency has said is responsible for the MBE compliance. It can be the MBE liaison for the department. It can be the contract manager for a particular contract. It could be the procurement officer. The thing that we say is somebody needs to be responsible. We don't say who that somebody is.
Because we have a high voltage chiller contract that we're going out on for 3 years that DGS is monitoring because of the dollar level.
Okay.
It has an MBE requirement, and when I was looking over all the MBE forms for the first time, I noticed there's reporting requirements
Oh yeah.
that go to the MBE, so I would like to assume that since they're getting reports, they're monitoring the MBE compliance.
I mean DGS?
No.
Who?
The
Who?
MBE organization gets the reports.
When you say the MBE organization, what
Okay, I thought they did.
MBE organization are you talking about?
The group that,
Governor's Office of Minority Affairs?
right, exactly.
That's wrong.
That's wrong?
No.
Okay.
GOMA does not monitor.
Okay. Okay, good. Because I wasn't sure, because I saw all those forms and they're, the contractor's supposed to on a monthly basis.
The prime contractor and each MBE subcontractor on a monthly basis is supposed to report. And it needs to be identified who they're reporting to. And I don't know for a DGS contract whether they report to DGS or that's probably something DGS has delegated, in this case to
it's more
DHMH.
likely Sheila, who's our procurement officer for Spring Grove.
Who's paying the bill? DGS or you guys?
It's above our dollar approval level.
Yeah, but somebody, who's actually, who's paying the invoice?
You're
It's-
talking about that contract. that you-
You're at the HVAC chiller, right? It's, you know,
Has
70,000.
that been approved? That's been approved.
That is, the bids are coming in shortly.
But you said bids are coming in, it's 9,000.
No. I'm just asking a question. If it does come in and it is approved, which more than likely is going to happen.
It should be on the forms.
Yeah.
Well, and when I looked over the MBE forms, a lot of those forms are going to the MBE office, and I just assumed.
When you say MBE office, you mean Beverly Spence, here within DHMH?
That's what I'm thinking.
It doesn't necessarily happen that way in,
Because when
Yeah.
you talked about project team, the first thing I had in my mind is obviously the person that's coordinating MBE is going to be part of that team.
That should be an integral part of the team. Somebody whose specific focus is MBE compliance, because that's part of the decision. That's part of the remediation if they're not doing it properly.
'Cause I didn't
So,
want to be-
yeah, if there's an MBE goal, whoever is the appropriate person that is responsible for MBE activities should be part of that team. But that's up to you to decide who that person is. Let's see, the adequacy in meeting the needs of the project, i.e. is the contract satisfying the intended purpose. Project team may also be brought together on an as-needed basis, as mentioned on 780 or some slide of that nature, to advise whether to exercise a renewal, do a modification, terminate, suspend, file a claim. If these things are considered, as I said before, even though you speak with one voice to the contractor, usually the contract manager or even the procurement officer is not going to make a unilateral decision on things of this nature. Usually you will want to vet this through the contract management team to get their collective opinion. And from my selfish perspective, I always like to have cover. That I always like to get the higher ups to approve things so that you're not subject to, you did what? Why did you do that? How come you didn't come to me? Why didn't I know about it? I don't like not knowing about things. And so I generally like to, anything that I think is of any significance, before I do something, I run it up the flagpole, to use the terminology, and find out, am I going to be supported? Am I going to be told not to do it? Am I going to be told to do it sooner? What's the situation? So that's what this group does, gives you some of that support.
so I've got a question. Suppose you're holding these meetings, you formalize it, the notes or whatever, the recommendation, then you give it to the procurement officer?
Well, it
Then-
depends. If you're taking an action like a claim, suspension, termination, modification, renewal, it's the procurement officer. If it's like a remediation plan, where you're going to the vendor saying you need to step up the work, something like that, it might be the contract manager. But these type of actions, yes, the procurement officer. And presumably the procurement officer would be part of this group to help make these decisions. So his or her voice can be heard at that time. And it should be assistant AG, it should be, bless you, someone from budget, someone from MBE, and one or more people from the program. The stakeholders that have some kind of role in this should be represented, so they have a say in what's to happen. And at least, even if they're overruled, even if it's like a vote of 3-2 or something like that, at least their part was heard and they're aware of what's going on. And I'm not saying it's a pure democracy, because certain times certain people can be a majority of one, but at least if you're looking for consensus, if you're looking for the differing of opinion, you have something where it's discussed and either you get consensus or you get a majority vote, but everyone knows what the decision was. So this is just a possibility. And again, we're talking about major contracts. You're not going to do something like this for $20,000 a year, presumably. But you decide to what degree you want to do something like this. The project team may also advise whether to increase the contract cost ceiling. If you have a cost reimbursement contract, you're supposed to have a not to exceed ceiling. And what that means is if the vendor gets to the not exceed ceiling, you have two options. Option number one, increase the ceiling. Option number two, don't increase the ceiling. And if you don't increase the ceiling, the vendor stops work when the vendor gets to the ceiling. So does this team advise that we change the ceiling or leave it as it is? And now we know we're not going to have the vendor do any more work. So either we'll do without it entirely or we'll make provisions to have state personnel do it or something else. So that's if they have an indefinite quantity contract, cost reimbursement, or any contract with a not to exceed cost ceiling. So that's a decision that could be made. Any questions on that? Probably not. Options. And Gary was starting to talk about this, I think, the first day, and I said, we'll get to it, just hold off. And now we're getting to it. Option. Define. Option means the unilateral right of the state under a contract to extend the contract for an additional period of time or to purchase delimited additional goods or labor or to purchase materials or facilities that have been leased. And this is a definition that is in 2101, 0201B 61, that exact definition. So that's what an option is. Options are almost always included in contracts when the contracts are awarded. Almost always. There can be a situation, and I actually have done situations, where you do a modification and you add the option through a modification. And we're about to do one just now where we have to do we are going to do a re-procurement for another agency. And in order to allow time for services to be continued while we do this re-procurement, we have advocated that the agency in question go to the vendor in question and ask for them to do a 6-month modification to extend the contract with 3 one-month renewal options. So that if we are not completed in 6 months, we have an option to go to a 7th month, an option to go to an 8th month, an option to go to a 9th month. So that's via modification, adding an option. But that's under very unique circumstance that a procurement was done for various reasons. There cannot be an award through that procurement, and now there's going to be a re-procurement, but in the meantime, you have to continue services, and you do that through an extension, and an option will be part of that extension. But other than that circumstance, which isn't supposed to happen, because we're not supposed to do procurements that get canceled and have to be done again, then an option is to be in the contract to begin with, in the specifications to begin with. Let's see. If an option is, and you can have an option, although the most typical option is for time, to add time, there could be an option that relates to work, that you have the ability to, well, as was stated today, they could have had the option for the vendor to do 2 days of work with an option to require a third if you exercise the option. Or you can have an option for the vendor if it's housekeeping services. We have an option for them to come in and clean all the exterior windows once a year. We're not saying we're going to do it, we're saying we may do it, and if we do it, we have a price for it, all the terms and conditions are established, and maybe we will and maybe we won't, it's an option. Versus if it's not addressed, external window cleaning, and you decide that you want to do it in the future, then you have to do a modification and get the agreement of the vendor and work out a price with the vendor. So an option is something that is unilateral. State simply says to the vendor, do it. And nothing has to be negotiated. Let's see. If an option is considered for inclusion in a modification, the option must meet the requirements of the definition on the prior slide. And what that means again is unilateral. Unilateral means state has the right to do it or not do it. The vendor does not have the right to disagree with it. And I have people come back to me and say, is that fair? Isn't it fair that it's by mutual consent of the vendor? And my answer is, well, first of all, if it's by mutual consent, it is not an option, because the definition says that is the only circumstance in which there is a true option. As soon as you get to mutual, it's a modification.
Because option is already there in the contract when it was issued to them anyway.
An option needs to be in the contract. They need to know, because as I said, it's not supposed to be something where there is any substantive negotiation, any substantive determining what is to be done, and in particular, you're not supposed to have to figure out with the vendor what the price is going to be. It is something that is identified in the specifications, the vendor bids to it, and then the decision is you will either exercise it or you will not exercise it, and you make the decision of which it is. Even if a vendor doesn't want you to exercise it, you have the right to exercise it. Even if the vendor begs you to exercise it, you have the right not to exercise it. And not exercising is not a termination. It's just not extending it, in so many words. So they can't come back to you and try to get incurred expenses for a termination for convenience, because it's not terminated. It just means we're not picking up an extra period of time or not picking up the ability to ask for extra work. It's our decision.
So I had a question actually. If there is, the contract says it's a 3-year contract with an option to renew every year. So does that mean that after a year we can terminate it? If it's a 3 years contract?
3-year contract, what was the
With
second?
an option to renew every year.
Well, if it's a 3-year contract, the way we break this down is what we call the base contract and then the option term. So if you have a 3-year base contract, that is the contract term. If you have an option for a 1-year renewal option, then you're going to decide whether you're going to say to the vendor, okay, I'm exercising the option. The contract, in so many words, will continue for another year. And if you have 2 1-year options, you continue with the first year and either continue or not continue with the second year. Now, one thing, and I don't know whether you were trying to say this, one thing you cannot have is a contract that is annually renewable that does not have a finite termination date. You can't just have what is called a perpetual contract, what is called automatically renewable unless either party gives written notice to terminate. Not allowed. Has to be a finite time frame. You have to say how many options that you are possible, and then that is the amount of time that you can go and have options unless you go into modifications. All right, I'm going to have a whole lot of more information on options, including examples and things. So let's go through and see what we have said.
One thing to say is that the gross majority of the contracts that contain options, we exercise the option.
Yes. It's the old story of what he just said is if there's an option, probably 90% of the time or more, we exercise the option. And if I can say it this way, what it gets down to is, can I avoid doing a procurement for 1 more year? If the answer is yes, that's what I'm doing. I'm going to tell you that there should be more consideration in the decision than that, but I know that in reality, most of the time it comes down to, is there any way I don't have to do it right now? Answer yes, fine. I'm exercising the option. But we'll tell you what else you're supposed to consider. Meet the requirements on the preceding slide. As per the definition, there are 2 major types of options. Work to be changed, additional work, reduction in work, a change in the time for work to be performed, or renewals. Renewals is additional time to do something. Consider an option, including an option to renew a contract, as a pre-agreed modification that is only awaiting the state's execution of the option to make it effective. So it's something that all the details have already been worked out, including the price, and you either press your finger on the magic button and say yes, or you don't press your finger on the magic button and the answer is no, as far as whether it's exercised. So if you considerations for the option, you can reconvene the project team. You would notify, these are things that you typically would do. You get to the team of, should we should we exercise the option? And usually the answer is, let's see, I have X amount of furloughs, I have someone out on sick leave, I have this position that's vacant and I can't get filled, so am I going to exercise the option if I have it? Answer is yes. Even if I have to pay more money, the answer is yes. Because almost inevitably, if there's an alternative to doing a procurement, people take the alternative. Notify the contractor of the impending. So this is what we suggest, that usually you might want to tell the vendor that if you firmly intend to exercise the option, it probably is a good thing to put them on notice that you intend to exercise the option. But I will emphasize that putting them on notice is not the same as exercising the option. And we're going to get to that in a couple slides. You must obtain all approvals required for a contract modification, meaning that if there is an option, depending upon the contract value of that option, it may have to come to DBM, it may have to go to DGS, it may have to go to DO-IT, it may have to go to the Board of Public Works, and you cannot give an absolute notice to a vendor that the option is exercised if you must get an approval first, because you don't have the authority to inform a vendor that there is an actual picking up of the option if you have to get an approval first and you haven't gotten that approval. So that's why we have the thing of you put them on notice, but you don't give them the actual notice until after you have whatever approvals are necessary, and then you give them the notice. And maybe, this is a maybe, for the additional work period, you have another work initiation conference, just for the option. Okay, going to give you some rules now, and some of these shoulds be very elementary. Exercise the option before the contract expires. That is an absolute must happen. You cannot, well, to use the quote there on the screen, just as modern science cannot, as of yet anyway, bring the dead back to life, neither can you revive an expired contract. If you have an option and you do not categorically exercise the option before the previous contract term expires, the option expires. It is no longer there. And you can't go back and say, well, I had it, so why can't I go and exercise it retroactively? Because there have been law cases, court cases that have said it can't happen. It is dead. It is dead, buried, and incinerated, whatever.
You can issue an emergency procurement, can't you?
You might be able to do something afterwards, and we're going to get to some examples of what you might do. Let's see, business leverage renewal options. This is where Gary started to go on the first or second day, and I said, we'll get to this. So even though we know 90% of the more of the time you're going to exercise an option, we're going to tell you what you should do. A contractor can be invited to offer a price reduction or some kind of concession in exchange for the state exercise an option. Please, do you want to make me an offer I can't refuse, Mr. Vendor? That I know I have this option out there, and yes, we both know that I can either exercise it or not exercise it, and I'm really having difficulty making up my mind. Maybe you'll help me get over this indecision. And maybe a little bit of price reduction might really help me decide whether I want to exercise this or not. So if you want to help me make my decision, feel free.
Isn't that a form of extortion?
Well, no, because we say, don't extort. Invite, don't extort. Now, is there any question what the difference is?
It has to be done with tact.
Yes.
Well, they give you a draft letter to send.
So it's an invitation to sweeten the pot to help the agency decide whether to exercise the renewal or to do a new competition, because that's the other thing that's out there. We can always go and do a new procurement, and you don't have to let on to the vendor, but I'll do anything in the world to avoid doing that new procurement. I'm going to make believe to you that I really am considering that as an option. And as long as you believe me, fine. Maybe you'll come in and give me some kind of concession. Any
Does that mean that you make a modification?
Just
if
getting to that.
They do that?
that
Okay.
Yes, that does mean
Because
that.
that changes the
That changes
three-year
it.
contract at the first year.
Any reduction in price or other contract enhancements such as adding or increasing liquidated damages, bond, insurance, deliverables, any change must be added via a contract modification, because an option must be exercised as it is. And if you're changing it, you no longer have an option. So what you have to do, if you have something that now you want to change, is you have to have a modification that will take effect simultaneously with the renewal. And you work with your AAG for the language to do that. And basically what you do is you have a modification that says, predicated upon the state exercising option such and such to do for such and such period of time, upon exercising that option, the contract will hereby be modified to do the following: to add work, to reduce price, whatever the situation is. So that, number one, if you don't exercise the option, there is no modification because you didn't exercise the modification. And if you do exercise the modification, meaning the option, since this modification will be signed by the vendor and will be contingent upon the option being exercised, once you exercise the option, the modification goes into effect. But it takes some wording to get that to happen simultaneously and to make sure that you're not obligated if you don't exercise the option. But so you have to remember, you just can't make a change without going through a formal written modification signed by the vendor for which you get approval based upon the dollar impact of that modification. And then once you get the approval, then it's co-signed by the state and then it goes to the vendor. Talking about business leverage again, and I know this is going to sound very strange to some of you, and you're going to say yes in your dreams, but I'm going to throw it out there as something you can do. An agency can also do an early reprocurement to see which would be a better deal for the state: a contract to be awarded under the new procurement or the renewal option. So that's why allegedly, I guess I shouldn't say allegedly, since we have this in our advice on things going to the Board of Public Works, but what we tell agencies is you should seek to exercise a renewal option at least 6 months ahead of time, and maybe more than that, under the premise that if the answer is no from either us or the Board of Public Works, that if you need a contract in place, you still have time to do a procurement. And even though I can't remember, not only the last time, but I can't remember any time when the Board of Public Works has refused to approve an option, it's possible. So you need to have something in, and the thing that the board does not like to have happen is to be basically painted into a corner. Well, the contract expires in 2 weeks. And if you don't exercise this renewal option, the contract will have expired, and there's certainly not enough time in 2 weeks to do a new procurement. So, Board of Public Works, you have no alternative but to approve this option, because otherwise we'll be without service and nothing else we can do about it. And believe me, the Board of Public Works does not like not having an option to have a choice to either defer approval or to not approve something, period. So we're not supposed to paint them into corners. And you have been properly advised by me that you're not supposed to be doing that. Remember, you heard it from me. But going to this issue of reprocurement, what that means is if a reprocurement is done, the solicitation should advise vendors that the agency does have an available renewal option that it still may exercise. And so they're put on notice that with this procurement, we either could make an award or we could simply go ahead and exercise the renewal option that's already available, depending upon, and what it says is, we will take whichever is more advantageous to the state, exercising the renewal or awarding the new contract. Some type of price for the renewal option should also be disclosed so the vendors know the target they need to beat. Now, sometimes that can be a finite price. You have to have some consideration here for what you reveal. And usually you might have to talk to your assistant AG, because not every price on a contract is publicly disclosable. What we call the high-level price is always publicly disclosable, i.e. if you go to the board for a contract award value of $1 million, you can tell anybody that contract award value was $1 million. But if that $1 million was the result of 20 different subcomponent prices, some of them with indefinite quantity, some of them fixed price, etc., all those, what we call intermediate prices, may not be publicly disclosable. And so you may have to have some discussion with your assistant AG of what you put in that document as far as the target versus what you can't put in. And you sort of go to the price form. If the only price that you got from any vendor is an hourly rate, you can put the hourly rate in there, because that is the only price you have. But again, if the hourly rate was multiplied times an estimated quantity, and then you had so much for this one activity and a different set of hourly rates and quantity for another one, and all these subcomponents may not be disclosable. So that's just what it says. And you tell people, if you're going to give me a good deal, we'll make an award from this contract, but we don't have to. So they're advised that they might be wasting their time if they respond to it. You might be wasting your time for going through the motion. But from your standpoint, even going through the motion may pay off even if you don't award under the new contract. It may simply validate that you already have a good deal, which without going through this process, you might not know that you had a really good deal.
So Joel, just a question. What if you, like for example, a Mason case, somebody go out to bid, you know, deciding whether to renew an option or something, and somebody comes in with a real cheap price and you know they don't really know what they're doing, are you forced to take that?
No. The question was, she used the example of D.R. Mason, where she said, what if you do the re-procurement and you have someone with a low price and that low price is lower than your renewal option, are you obligated to award? You're never obligated to award. If you believe their price is too low to do the job, you find them not responsible. Hopefully with a good justification, better than I had the first time that I did that. But no, just because they come in with a lower price, if for some reason you don't believe it, if they're non-responsive, if they're not responsible, you still don't award to them. So maybe the lowest price one gets eliminated because they're non-responsive, and the second lowest price is not less expensive, so you've done the procurement and you still make an award, you exercise the renewal option. It's something that can be done.
What did you call that bid earlier with the technical evaluation and then the financial evaluation?
Multi-step?
Yeah, multi-step, that's what I was
Yeah.
thinking. I was trying to recall it, because on certain jobs, obviously, the multi-step is good for the technical evaluation as a separate entity unto itself.
But what it gets down to is you have a renewal option, is it going to be a better deal for the state to make a new award than to exercise the option? And if you do this, you have to make a decision. Let me see. So continuing on this, if you do a contingent procurement, if you want to call it that, as applicable, the price to be disclosed might be the fixed price for the current contract, unit prices, price from a model, etc. I've talked about that. Consult with your AG about the permissible pricing disclosure. Excuse me. Possibility of the agency doing such an early re-procurement might also, and this could happen, might also encourage the current contract to enhance its renewal option price. If they think that you're seriously contemplating doing this early re-procurement, lots of times they will use that as the reason to come in and make you an offer. Well, how about this? Even though my option price is such and such, if I offer to reduce 10% from that, will you exercise the option? Well, I'll have to go talk to my project management team, and we'll have to see, because we really think, you know, in this economic environment, it's a buyer's market. So I don't know, 10%, well, I'll just take it to somebody else and we'll just see. But I don't know if we're going to not go ahead and do the procurement, because, you know, we have the right to do this procurement, it's still not award, so I don't know. Well, 15%, would that convince you not to do a procurement? Well, it obviously convinces me more than 10%. Now, this is hypothetical, but that is what is possible. If a vendor really thinks they're getting a good deal, they're getting a good deal under an existing contract, and they have the prospect of continuing that versus the risk, if there's a new procurement, of losing it, that might be the case. And a lot of this does come down to what are things like currently in the marketplace. If you have a situation like now, when supposedly vendors are falling all over themselves to try to win business, and you have done a couple procurements, or you're aware of other states that have done procurements, and that they've gotten prices like 20% lower than what has been paid even 2 years ago, then the more knowledge you have of what's going on in the marketplace, the more you have the ability to make these decisions and be convinced of either, nope, we got to go out and do the procurement. So unless you're coming back with a whole, like a 30% reduction, we just got to go out and see what we can get. Or if you know the most that is being reduced is 20%, and the vendor comes in and offers you a 20% reduction, do you take the option? Do you take that and say, okay, we're not going to do the procurement, and do a modification? And part of the other decision is, if you have a 1-year option, but you're going out for a 5-year procurement, even if they offer you a reduction for a 1-year option, maybe you'll still get a better price for the 2nd, 3rd, 4th, and 5th year by going out with the re-procurement than simply exercising the option and waiting another year to do the procurement. So there's a lot of considerations. Although I know that most of them is, do I have an option? Yes, I will exercise. You should make some of these other considerations. Let's see, might encourage. So if they come in and give you a sufficient reduction or enhancement, you may decide either not to do the procurement at all, or if you've already issued it, you may cancel it based upon the vendor coming and offering what you perceive to be a significant reduction. And the fact that you even started the procurement might be the reason to bring them in with that enhanced offer. So we can do a modification to take them up on it. Obviously, if an agency does such an early re-procurement, it can end up doing all the work of a procurement without making an award if the current renewal option is a better deal, or the contractor belatedly offers a better deal and the agency cancels the re-procurement, but the effort of the re-procurement either validated, as I've already said, that the renewal was a better deal, and lots of times, believe me, if you're going to the Board of Public Works, one of the things you are supposed to identify in the board item is why renewing the option is in the state's best interest. And what almost inevitably happens is you will write a couple sentences that say why it's in the state's best interest. This vendor is doing an excellent job. This vendor is performing above expectations. And we think we have since the price was quoted 3 years ago, we think that it's a better price than we could get if we went back in the marketplace. And no matter almost what you're going to write, Howard Friedlander, who is the representative of the treasurer, is going to write to us if it's a service and say, there's not enough justification for the option. Go back to the agency and ask them to give you more information about why exercising the option is in the state's best interest. So we will come back to you and say, can you give us a beefed up explanation of why the option is in the state's best interest, including numbers and including if you've gone out and done looked at websites of prices, or just what you've done to help come to the conclusion that the option is a better deal than a re-procurement. So it isn't just you say it and everyone's going to say, okay, it's fine. Sometimes there will be some real challenges on the advisability. Let's see. So it may validate the renewal was a better deal, or it might prompt a better deal from your existing contractor where they sweeten the pot. So that's a possibility. While renewal type options are by far the most prevalent type of option used in state contracts, options to add or subtract work activities or quantities also exist. Most of you, when you think of options, think of 1-year renewal, 2-year renewal, something like that. But again, an option can be to add or subtract work or some other type of activity. Most of the recommendations for trying to get extra value from vendors before exercising renewal option also apply to these types of options. Invite the vendor to reduce his price, provide additional value as an inducement, a sweetening of the pot, and let's see, to either exercise an option providing more vendor revenue or not exercise. Let me read that again. Invite the vendor to reduce his price and whether provide as an inducement for the agency to either exercise the option, because if we exercise the option, they're getting more business. That's the bottom line. They get more business, they get more money, they get more profit. So if you want this additional business, give us some inducement, because if we don't exercise it, that might be money that, even though it's an option and they shouldn't count on, lots of vendors, since they know we typically renew, lots of vendors will count on that money. And if there is even the possibility that we're not going to do it, again, that might incentivize them to make you an offer. All right. However, for renewal type options, it is unlikely that the prospect of doing an early reprocurement in lieu of exercising an option would be a valid alternative, but an early reprocurement might be a plausible leverage strategy if the agency has an option to terminate a contract early for its convenience without liability to the contractor. That's a different type of option, and that's an option that we recommend under certain circumstances. And it's dealt with somewhere around slide 715, but the alternative of an option to extend a contract term further or for an additional period of time is an option to shorten the contract period without the vendor having the ability to go after us for incurred expenses. If there is a termination for convenience, which termination for convenience states that the vendor, and we will deal with that later in this class, that the vendor has the right to submit a claim for incurred expenses, which means if we terminate, and for convenience supposedly means because we want to, not because there's a performance issue with the vendor. But if we terminate, supposedly they can come back to us and say, pay me X amount of money because I've already sunk this amount of cost into the contract. I'm now not going to get it paid back because I'm not going to be able to amortize it over the full contract duration, and so pay me this money. And under the right circumstances, if we have a clause in the contract that says, let's say it's a 5-year contract, except at our option, we can get out of the contract after the 3rd year upon, let's say, 2 months written notice without liability to the state. So that's an option. It's not one that you typically think of, but we have the option to get out without necessarily having to face the prospect of incurred expenses. And so that might be something we decide is the best interest of the state 3 years from now, to just give them the 2 months notice and get out of the contract. So maybe they will give an enhancement so we don't exercise that particular type of option. And we do more on this back later. Let's see, if the agency can do a procurement, see the results, and then be able to terminate the current contract without expense, the vendor might offer lower prices to forestall such action. So it's the same issue. If you can do a procurement before the contract is up, and instead of not extending it further, but actually say, okay, contract's over, we're going to exercise our option to get out of it, again, a vendor might give you some enhanced offer so that you don't do the procurement, or you don't actually implement the procurement and simply will not exercise your escape clause to get out early. Is that understandable? Are you getting what I'm saying?
I have a question. if the state determines that they want to, you know, opt out early, is there, like, do you have to notify them? Is there a certain amount of time you have to notify them before an option has to be renewed or the?
Okay, the thing about, should you give them a certain amount of notification, I think I deal with that on the slide, so I will get to that. The issue of if you have this early out provision, well, the early out provision will tell you what kind of notice you have to give. And it might be 1 month, 30 days notice, it might be 60 days notice, and then you can escape. It's whatever it says. But otherwise, the general recommendation is we don't put minimum time frames, and I'm going to cover why. Let's see, business leverage.
Less time than that, you'd be subject to some sort of plan.
What was that?
If you escape any less time than that, you'd be subject to some sort of plan. If you had an escape clause of 30 days, and you say, look, I'm getting out the following, they can come back and say, no, we've got 30 days.
Yeah, if you have to give them 30 days notice, you have to give them 30 days notice, and they still will perform for 30 days. If you, for some reason, have to cancel immediately, then you're not canceling under that provision where there's no liability. Maybe it's a default situation. I don't know if there's a situation that we can think of where you'd have to get out immediately other than default. So, possibility. Let's see, business leverage, praising the contractor. And it does happen, it can happen. Acknowledge good performance. As mentioned earlier in the class and in the appendix, which we will get to sometime. Sometimes praise, if it is deserved, and I emphasize if it is deserved, is a powerful contractor motivation. Vendors are usually seeking more business, and just as Maryland agencies often place great importance on the statements of current or prior customers of a bidder offerer, we always want to see your references, except for 1989 for the D.R. Mason situation where I didn't ask for it, but have always changed it since then. You had to be here. You wanted to go and do that MTA stuff, so you lose. We like to see other governments are saying that a vendor has done good work, because one of the things that has been, I think the federal government has taken the lead on this, is the primary indication of future performance by a vendor is the past performance of a vendor. And that has been found, and it certainly makes sense, that vendors that historically have done a good job in the past are likely to do a good job in the future. And conversely, vendors that have not done a good job in the past are more likely than not to do a good job in the future. So that's why we ask for references. We want to see what the vendor has done. We want to see what other customers have said about a vendor. How many say good things, and how glowing are they in the comments about the vendor? And that has an impression on us. And just like we like to see the vendor having done good work from other vendors for other customers where they are extolling the virtue of the vendor's always on the lookout for someone else that they can get a glowing testimonial from. And so to the extent that we feel that it's appropriate to give a letter of praise, vendors will often value that, because then they can use it for future procurements to say, look, we did a good job for the state of Maryland. Here's what the Department of Health and Mental Hygiene thinks about us, or the Department of Environment, or General Services. Look how good they say we did a job for them. So the notion of being able to get that letter of praise might help spur a vendor to not only do a proper performance under the contract, but maybe that little extra something. Because when they do something good, you give them a letter that gives them a pat on the back that says, we appreciate the extra effort you did. We had this JCO certification coming up, and you pitched right in there, and you got the place extra spiffy, and you got all the stuff out of the way, and we passed with flying colors, and part of it was as a result of your good efforts to cooperate. And so a letter like that will be something they will use in the future for other customers. So it's a possibility of doing things like this. And you don't think of this as a leverage to try to get good performance, but this could, if it is deserved, and not just they ask you and you don't really like them that much, but you feel obligated to say something nice. That shouldn't be the case. But if you give them the attaboy because they've gone above and beyond, that's something that they will value. Let's see. If the contractor believes it can obtain and use letters of praise or a reference in pursuit of new business, it might seek to make an agency's contract a model of exemplary performance, but note the cautions regarding providing references, which we deal with in the appendix back around slide 838. So when we get there, we'll note the cautions. We're going to tell you about that. Now we get into some real situations and see what you think about them. Situation number one, an agency notifies a contractor of its intent to exercise a contract's first renewal option. So, and coincidentally, this is for the medical services at Spring Grove. Mm-hmm. So the contractor says, so when I give them notification, I'm going to exercise the first renewal option for the medical services contract at Spring Grove. The contractor, who is GBMC at that time, GBMC agency, said, option? What option? What are you talking about? There's no option. And along with saying there ain't no option, they say, look, we're losing money. We're losing money big time. We really bid this contract too low 3 years ago. We want out of this. We don't want you to exercise renewal option. So they're saying, number one, we don't want you to do it. Number two, even if you want to do it anyway, there's no option. And based upon their reasoning for no option, when I'm saying there's an option, how can you say there's no option when I know there's an option? Because the solicitation clearly stated there were 2 one-year renewal options which the agency could exercise at its unilateral option. And the contractor has submitted prices for those 2 option years. So yes, there are options. But in this particular instance, the contract had a place on the front page that said renewal options, where it would identify the period of renewal options. And in that space, where it had for the identification of renewal options, it did specifically say none. So the vendor said, what part of none don't you understand? And I'm saying, those are fighting words. But that's what they said. I don't care whether the RFP said renewal options. I don't care whether I gave you prices for the renewal option. The contract, which is the document that supersedes all other documents, says none. So we are contesting the fact that there is a renewal option even available under this contract. And the contractor said, now on the other hand, if you want to pay us more money, about 20% more or something like that, then we'll talk about continuing to provide the medical services here at Spring Grove. But if you're not going to pay me any more money, no option, contract's done with, we want out of here. So based upon that scenario, does the renewal option exist?
No.
We have a no. We have a shaking of a head no.
Yeah, because we don't give the duration. We have a renewal option, but we don't have the duration.
It was in the RFP.
Was there a pre-proposal conference?
There was a pre-proposal conference.
Did they address
There's renewal options in the RFP. They bid prices. They gave 2 prices, one for option year 1, one for option year 2.
It does exist.
Anybody else?
So it was in the contract itself that it had an option.
It was in the RFP that there was an option.
There was an
The contract incorporated the RFP by reference, but on the front page, where it specifically says renewal options, it says none.
You just said
It's
the contract
debatable.
incorporated the RFP?
Yes. I said that.
That's all I need to hear.
Now, see, that would be like an example with the vital records. It was in the on the RFP, but by some obscure exception,
So you'd say it's still there.
well, obviously, I would hold them to the renewal.
Okay, we got 2 no's, we got 1 yes,
So I'll say
we got 1, I know the answer, but I'm not telling you.
no,
No? Or you're going back and forth?
Who says yes? Who says yes? Raise your hand.
Who says no? How many people say, I'll wait and see what you actually say? You're no? You're a no? You're a yes? No, you're a yes. Anyone else have any comments? All right, let's see. Answer for now. The contract incorporated the solicitation by reference. It clearly was a mistake that none had been entered in this space in the contract. A major change such as eliminating the 2 option years couldn't just be done by saying none. Since the contractor signed the contract, before there was an award, a change of this nature couldn't have been made just with this vendor. You cannot unilaterally negotiate and change the deal. If it was put out for responses as a 3 years with 2 one-year renewal options, you can't make a separate deal with the winner than the other vendors responded to. So none wouldn't hold water based upon, it's clearly in the RFP, you had prices for it, it clearly was the intent, other vendors had responded on that basis, so you just can't, if you did this for one vendor, you could only have done it through a modification to the specifications followed by a BAFO. That's the only way legitimately that could have been implemented, and so something as casual as an obvious mistake can't change the underlying requirement that there is an option. Since the procurement was done by sealed proposal, all offerers needed to be apprised if such a change was intended and allowed to submit a BAFO, which I said, since this wasn't done, it proved there was no intent to eliminate the options. The agency proceeded to exercise the renewal option. I don't care, GBMC, whether you say the option isn't there. I'm exercising it. What are you going to do about it? And what they did was, after I gave them the notice that said, we are proceeding to exercise the option, they simply went ahead and did the work. But initially, and in fact, they used Piper and Marbury. I remember that was the lawyer that they used to come in and contest it. And are they still in business?
Oh, yeah. They're just called Piper.
Big time law firm in town. And I was like, ooh, Piper and Marbury. It's got to be something valid if they're using Piper and Marbury. And then I started thinking, and I went and talked to my lawyers, and we don't get intimidated just because they have high-priced lawyers. The answer is yes, we have the option. So if you want to do something about it, you do something about it, but we're exercising it. And they didn't do anything about it. And we didn't change the price. All right, answer for the future. Now this is a duh, pay attention. Don't write things you don't mean. I was also advised that I should instruct people, not just in this class, but each time I do a presentation, you should check your math. Just remember, you heard it from me. Always check your math in bids. Let's see. Pay attention to the details. Make sure the contract says what it should say and isn't contradictory to the solicitation. All right. Any questions with that? All right. Going to another option. Early 1990, contracts were awarded to multiple vendors to provide primary health coverage to 20,000 people who had been on general public assistance. GPA was 100% state funded, was a 100% state funded program that was eliminated back when Schaefer was governor, when I encountered the first instance of furloughs and pay freezes and things like that, around 91 or 92. So as part of the deficit reduction back then, GPA was eliminated. Since it was 100% state funded, it was a big ticket item that I guess was an easy target for elimination. So there had been 20,000 people roughly on GPA when it was eliminated. And the other aspect, if they got GPA, they automatically got medical assistance. So, several years after the elimination of the General Public Assistance Program, the state had some money again. So I guess good times are here again. So at that time, several $1 million was funded to provide primary health care for the 20,000 approximately former GPA recipients. So Now, 2 or 3 years after we've eliminated the program, we have some money, we can start providing some type of basic medical care for these people. It was firmly believed that the level of funding for this effort was inadequate. If you got $3 million is just a drop in the bucket. Whether it's 3, 4, I don't remember how much it was, but whatever it was, never going to go far enough to cover 20,000 people, so all we can do is the bare necessities, just the very basic health care. Because of the limited funding, contracts were awarded as not to exceed amounts to handle a specified number of clients. So it was not per client, it was not on a fee per service, it's how many clients will you serve? 200, 500, 1,000, and you gave a price. 200 price is $300,000. For 500, the price might be $1 million. So you had fixed price contracts for the clients to serve a given number of clients. But the essence was it was a fixed price. Let's see. It was assumed that vendors would only be able to handle basic medical needs and would have to be very efficient to stay within the available funding. Most of the vendors who even offered to do this were nonprofits because no one figured they could make any money, so the only people were entities that were doing this just to serve their fellow man and to do good for the public. After contracts were awarded, each vendor tried to enroll the number of clients authorized by its contract. If you had a contract for 200 and you said you would serve a given geographic area, you did outreach to try to get people in that area to come and enroll with you. And everyone was doing that. We had, I think, 20-some vendors that got contracts. Enrollments trickled in. About a year and a half after the contracts were awarded, they only had around 6,000 people signed up out of the 20,000 that were on GPA when the program was eliminated just a couple years earlier. So, based upon the available evidence, the agencies were doing outreach. They were out there inviting people to come and sign up with them and get their health care with them. It's going to be free, so come in and get this free health care. All you have to do is come in and register with us. Come one, come all. And if you meet the income limits, etc., we can sign you up, we can give you free care. And despite doing this for a year and a half, less than a third of the expected number of enrollees were actually enrolled. And so at that time, we were starting to put 1 and 1 together and come to 2. And that is, maybe there were 20,000 on GPA back 3 years ago, but there's not 20,000 that are available at this time to sign up. Either they've moved, they've gotten jobs, they've gotten on disability, something has happened. And the something might have been SSI, Supplemental Security Income, whatever the situation, apparently they're not out there. And so, what originally was thought to be a very stingy funding scenario, that X number of $1 million to serve 20,000 people, when all they had to serve was 6,000, and they were fixed price contracts, they were looking pretty good now. When they were thinking they were going to have to scrape by and get additional grant funding and all kind of fundraising to help cover expenses, now they're sitting pretty. And this is a positive income flow that is much beyond what they expected compared to their expenses. So it turned out to be very lucrative the way the contracts were awarded. The vendors got a flat monthly amount to provide specified basic medical services for up to a given number of former GPA clients. As long as the vendors were making appropriate outreach to try to enroll participants, they received their monthly amounts regardless of the number of people who actually enrolled. The first renewal option was coming up. What would you do?
Definitely go out on re-procurement.
Re-procure.
Yep. With the new figures.
Anybody else? What would you do? You want to say something. I know you want to say something. Anybody else?
Well, I would try to figure out why this discrepancy. I mean, just because, I mean, you might be guessing, well, I think they got jobs, I think they moved. I mean, were they really doing the outreach?
Yes, they were doing the outreach.
They were doing?
That was verified. They were doing what was expected. And because the agency wanted to have the medical care given, they were very much in tune with what the vendors were doing. And both parties, both we and the vendors, we both came to the same conclusion. Now, we're not sure why, but it's not that we're just missing people, it's apparently they're not there. Or if they are there, nothing we're doing is going to turn around and get them to come in. So whatever it is, we're not going to see anything more than a trickling of increase. If we haven't done it in a year and a half, we're not going to do it.
That's right.
And initially it was a 2-year contract. So you're coming up to the first renewal option.
All games changed.
And you're saying, go out and do a new procurement. So how many people would agree, don't exercise the option, do a new procurement?
I don't think the vendor's going to do a 60%
And you
change.
you agree? All right, we have a second agreement. How many people, that's what you would do, a new procurement?
Do the option with a mod to reduce the price.
What was that again?
Do an option with a mod included to reduce the price.
Oh, so you would say you would exercise the option, but you would do it simultaneously with a modification that changed the circumstances to reduce how much the vendor is getting. You can do that?
The vendor's not going to agree to that.
Yes, if you're doing a reproduction.
Vendor's not going to agree to it?
Not to cut
Is that
60, not to cut
is that
60%.
something that could be done, what she just said?
Yes,
Okay, but they're never going to go for it.
yes, they will.
You never know.
They may go.
Why would they go for it?
Well, because if you do a reprocurement, you have new figures, less people are gonna bid less. And if they wanna hold on to your business,
There's
they'll,
no guarantee they'll win the reprocurement.
Reprocure is the same vendor's going to win anything. Let's see what was done. What was done? Requested all vendors to agree to a contract modification to switch to a per capita funding. Under per capita funding, vendors would get a fixed monthly amount for the actual number of clients enrolled with that vendor each month. So if they came in the door, the vendor got paid. If they didn't come in the door, the vendor didn't get paid. Vendors were told that any that didn't agree with the modification would not have their options exercised. Leverage? We have the right to do that. You play the game, we'll exercise. You don't play the game, we won't renew with you. All of them agreed to switch to a per capita basis. And so we ended up paying less money. Now the money was used for other good purposes, but those vendors didn't get a windfall because of the circumstances being different that was anticipated. Option alternative. If there had been any belief that in the future a flat amount contract might prove more beneficial to the state, the modification might have been written for the state to have the option. This is where you can get a different type of option of either paying the vendors on a flat amount or per capita basis. So it would allow us on a certain amount of notice to switch back and forth between per capita or flat. So if circumstances change in the future, we could go back to flat. So that's something that the modification could have done. An option to switch to a different pricing methodology. Let's see, if this were done, the per capita rate or a formula to calculate it would have had to have been in the modification, since there is not to be negotiations concerning any substantive aspect of an option. That is a constant. You don't negotiate. So here's an example of an option that could have been added via a modification, as long as all the circumstances of the option, including how the price would either be determined or the actual price, would have been in the modification. Let's see, option alternative. If the modification included such an option, it would need to address when a change in payment methods could be made. And here's again different aspects of that particular option. Could you just do a one-time change and that was it? That we have the option to change back to flat rate, but we only have one ability to do that in the course of the contract, and if we do it, that's it, we don't come back. Or whether on each anniversary we could say we're going to do it this way versus the other way. We have the right once a year to change which methodology we would use. 6 months, monthly. These are all possibilities that we could have put in there that we had the option to do. As with an option for additional time, an option for additional activity is designed to afford the state with maximum flexibility. Example of an option. What this example illustrates. This example illustrates the inherent difficulties of initiating a new program. You start with what you think is going to happen, but you never actually know, if you haven't done it before, whether things are going to turn out the way you think they're going to turn out. And sometimes they do, and sometimes they don't. So there will be unknowns, far more unknowns for a startup type of program than one that has been in place for a while, where you have experience in what is happening. So you make your best assumptions, your best projections. You structure the contract the way you think will best achieve the purpose of the program. And to a degree, you see what happens. Now, that may not sound like rocket science, but sometimes you can't get any more specific than that. You do your best to anticipate, to give flexibility, and you see what happens, and you adjust. However you is best can do, you adjust to what actually happens. What this example illustrates, the advantages and flexibility of renewal options. With renewals, a contract can still run as long as originally desired if everything is okay, but if things don't work out for any reason, the contract can end after the base term without resorting to any type of termination. We said, after 2 years, unless we exercise the renewal option, the contract will be over for any vendor who did not agree to the modification. And it's just over. They're just don't have the contract. If we'd have done a re-procurement, then they'd have been able to participate again, but we figured there'd be enough vendors that would agree to the modification that we wouldn't have to do a re-procurement, and we would still get what we wanted for a better result than what we had at that point in time. So we had that flexibility with renewals. If things don't work out, well, okay, we just said that. If an option isn't exercised, the contract simply ends. The leverage that is possible with options. If the vendor wants to continue to enjoy the rewards of the contract, it may have to agree to modifications that benefit the state. Flexibility, and how that illustrates that. Example number 3. Let's see, 5 minutes. All right, we can do this in 5 minutes. And I wish Gary were here for this one also. Situation, there's a public relations contract to develop and make media placements of messages for both men and women on the causes, prevention, reporting procedures, and consequences of rape and sexual assault. The initial contract term was for 6 months with one 6-month renewal option. The award decision was based upon the price for the initial term only. This was a sealed proposal procurement, and technical was worth more than price. So that's setting up the situation. For public relations contracts, it is typical for the RFP to state the amount of funds available for the campaign. $300,000, $100,000, whatever is available. The financial aspect of this type of procurement is usually the amount of the available funds to be retained by the contractor, i.e. its fixed fees, versus the amount to be used for media placements of the PR message. So, in so many words, if we have $300,000 available, which in this RFP it was stated there was a $300,000 federal grant for the base 6-month term. And the financial was, since we know there's going to be $300,000 spent, how much of that $300,000 will you, the vendor, keep as your expense to develop the messages, to go ahead and place it on radio and television, etc., versus how much of it is going to be the payload to actually pay for the radio and television messages and billboards and things of that nature. So $300,000 was available for the base 6-month term, but it wasn't known if additional grant funding would be received to exercise the renewal option or how much such funding might be. So that was the situation here. The procuring agency submitted an award recommendation to DBM for approval. And there were 2 responses. The 2 vendors responded to this RFP. Both vendors, coincidentally, responded with a price of $300,000 for the financial. So, not a surprise, since we told them $300,000 is available. While the recommended vendor quoted a much lower fixed fee portion of the $300,000 for the base term, they were going to keep less of the 300,000, which means more was going to go to place the message. The RFP said this breakdown was for informational purposes only, which certainly it shouldn't have said, but it did. So 300,000, and for informational purposes, tell me how much you're going to keep, but we're not going to use that information for any purpose, which means that you had no financial difference from vendor 1 to vendor 2. Our initial response that we could not make an award under this particular RFP because, well, let me go on and tell you some other things. This answer resulted from the fact that while there were detailed requirements for the development of the PR message during the base term and the placement of those messages with the non-fixed fee portion of 300,000, so the RFP said during the initial 6-month term for the $300,000, here's what you're supposed to do. So there was detail. There was not one word in the RFP of what was to be done during the renewal period. So yes, we have a 6-month renewal option. But when you get down to it, a renewal option to do what? For how much? Well, we don't know what you're going to do, and we don't know how much you're going to do it for, which the bottom line means you don't have a valid renewal option at all. You thought you had a renewal option. There were the appearances of a renewal option, but when you get right down to it, it didn't meet the requirements for what is required for a renewal option, where it has to be certain what is to be done and the price to be paid for it. And here neither one was there, neither what was to be done nor how much was going to be paid.
They could have put one more sentence in there saying that on the same basis.
Well, even if it was the same basis, since the initial part included determining the appropriate message that was, and the commercials. So it was a large part of the money was, do we do 2 commercials, 3 commercials, producing the commercials, doing testing the commercials to see whether they were valid. So presumably, once they did it for the initial 6-month term, there's nothing of that nature to do for the 6-month renewal if it happened. So are they simply supposed to continue to place messages on radio and television for whatever amount was in the grant for no more money? Or were they supposed to do it for like $5,000? And it would be one thing if it was work that would be consistent, that you could say, yes, you'll just keep doing the same work for the same price in the renewal option. But here, that didn't apply. Since DHMH did not know if it would receive additional federal grant funding to even exercise the option, it didn't say what was to be done. Because from their standpoint, well, if we don't know we have the money, we can't say what's supposed to be done for an option that we don't know if we have money to even exercise. And the bottom line was, that means there's no option. Even though the recommended offer had communicated that despite the for informational purposes only wording of the RFP price form, that it was going to retain less of the base term $300,000 as a fixed fee, there was no way to know what either offer was going to do for the option term. So DBM determined that there was not a valid option, and without a valid option, the procurement should be redone. But that's not the end of the story. There's more. In response to DBM's refusal to approve an award, the requesting agency, what is that, Health and Mental Hygiene? Yeah, that was it. Said the federal grant funds for the campaign had to be expended. Would you note slide 574, we need to remove a were. The federal grant funds had to be expended by a given date or they would be lost. Doing a re-procurement would preclude the expenditure deadline from being met. So, i.e., if we do this over, we don't have any money to do it to begin with. So what good is that? And DBM was told, we told the agency, this is not something you do an emergency on. This is not something that is harm to health, welfare, or safety that needs an immediate action to prevent or mitigate harm, etc. So don't think you're going to do an emergency. So, but we did agree that the loss of federal funds is not a good thing. So to prevent the loss of the federal funds, we agreed to approve the award with the condition that the renewal would not be exercised. So we basically shut our eyes a little bit because of the circumstances.
Pick up the extra money.
Also, the non-selected offeror, and this is more of the story, had already been debriefed, had not protested winning the award, and the protest period was over. So basically, all of this was an obvious ambiguity, that there was nothing in there about what was to be done for the renewal, no price and everything like that. The vendor that wasn't recommended for award had already been debriefed, had not protested, so it wasn't as if someone was going to be harmed by going forward and awarding on this basis that the vendor had already responded under. Both the 7-day period after the debriefing had expired and the fact the lack of deliverables was a patent ambiguity, obvious. So a protest of the specifications would have also been due before the submission of proposals. So it was late both because it was now more than 7 days after debriefing, and the only thing they could be contesting would be the specifications and the lack of clarity of the specifications, which was obvious, which the requirement is they have to protest that by the due date. So we knew that approving the award, despite the deficiencies with the RFP, would not cause a protest or disfavor the non-selected offerer. In this situation, all this happened during the procure stage, but what it illustrates is that just saying in a solicitation there is a renewal option doesn't necessarily mean there is. It still can mean that you can't get to the point of exercising it when you go to perhaps want to exercise it during the perform stage. If all conditions for the renewal option are not in the specifications, there is not a valid option, and as soon as it's necessary to negotiate any significant aspect of an alleged renewal option, the option becomes moot. Can't negotiate or you invalidate. It isn't there. So, went more than 5 minutes. So you're taking a... Thank you for reminding me. Isn't she polite? She only waits till I'm done. 15 minutes.